Hi, everyone. Thanks for joining us for this Tech Contracts Academy LinkedIn live conversation. We are David Tollen and Kathy O'Sullivan, both of whom work at Tech Contracts Academy and Sycamore Legal, both of which David founded. Hi, David.
Hi, Kathy.
So our topic today, software contracts, the license itself. Before we start, some quick housekeeping. We expect to go about 20 minutes. While we're both attorneys, this conversation is for general informational purposes. It's not intended as legal advice or to create an attorney-client relationship, nor is it intended as attorney advertising. It's also important to recognize that legal situations differ and the results depend on the unique law and facts that apply to them. If you have questions, feel free to submit them in the comments. And finally, know that this conversation is being recorded and will be posted afterwards on LinkedIn. With that, let's dive in. David, let's talk about some terminology that's fundamental to software contracts and what, in your view, is right or wrong depending on the type of deal. First, you've said that no one should grant a license to use software, yet those licenses are typical, such as vendor hereby grants customer a license to use the licensed software. What is wrong with that in your view?
So what's wrong with that is that it uses, or rather misuses, the copyright statute. It is not employing the language of the copyright statute. And I'm not just saying that that's important because of sort of formality and the desire to be really precise and follow along with the law. If you're not employing the concepts in the law that you're operating under, you have unclear language. So let me step back from that answer and explain a little bit better what I mean. So first of all, here we're talking about on-premise software licensing. So we're going to talk in a few minutes about software as a service. But right now we're talking about on-premise licenses. So it's the deals where the customer gets to make a copy of the vendor's software and put it on its own computers that it owns or at least operates. So that's the context here. So we need a license because without a license, the customer wouldn't have the right to do that. It wouldn't have the right to make that copy because copyright law gives the vendor, presumably it's the vendor, the owner of the copyright, a monopoly over exploitation of that work of authorship. Here we're talking about software, but it could be, a book, a play, a photograph, a sculpture, all kinds of assets that qualify as a work of authorship. So copyright law gives the owner a monopoly over exploitation in 5 different ways. So copyright law says only the owner can copy, reproduce the asset, the software in this case. Only the owner can distribute it. Only the owner can modify it. Only the owner, the copyright holder, can publicly perform or publicly display it. Those are concepts, by the way, that are more applicable to things like plays and photographs than software. A little complicated how they apply to software. But anyway, those are the 5 monopoly rights under the statute. And so a software license needs to give the customer one or more of those rights. None of those rights is the right to use software. There is no monopoly under copyright law on the right to use a work of authorship. And so that's the problem. If you grant a right to use, you're leading to your reader, your contract interpreter, to guess what that means. So, imagine you've got a software license clause like the one you just said, Kathy, where the vendor grants the right to use the software. Well, and maybe it's even more specific. Maybe it's the vendor grants the customer the right to use 50 copies of the software. You're left with kind of a puzzle. So what if using the software requires that you modify it? What if it's just something in the nature of the software requires some modification of the software to use? Does this license to use, without specifically saying there's a right to modify, include that right? What if it's more convenient to modify the software in order to use it, but but it's not absolutely necessary. What if it's more convenient, more effective to share the software with, say, the customer's certain partners, certain affiliates of the customer need their own copy of the software for whatever use of the software they're trying to make? Does that license to use software include the right to distribute it to those affiliates? You got all these question marks. That's the problem. That's the issue that you raise when you employ this vocabulary. So, you might be sort of scratching your head and saying, well, of course, copyright governs the right to use. What is he talking about? At a simple level, just look up the statute, look up the copyright statute. It is not one of those monopoly rights given to the copyright holder. But think about it this way. If I write a book, like my book, the Tech Contracts Handbook, and you have a copy, you don't need an intellectual property license from me to use it. You don't need a license from me to read the book and employ the ideas and the lessons in the book in your own contracts. You have a copy of Harry Potter. You don't need an intellectual property license to read it, because the owner of the copyright, me or J.K. Rowling or whoever, doesn't have a monopoly over that right. If you've got a copy, you can use it. And so it's the same with software. Now, why do we do this? Why do so many licenses grant the right to use? Well, it's natural. It's natural to think of on-premise software not in terms of copying, but using. I mean, that's what the customer's really after. But until Congress executes a major change in the copyright law to accommodate more modern copyright assets like software, that's not how it works. That's not how the statute is structured. What we need is a license to reproduce. The right to use is actually there. Once you have the copy, you can use it. If you want to restrict how the customer is going to use the software, you got to put that in the contract. There's nothing in the underlying law that's going to do that. It's going to restrict the customer's right to distribute, et cetera. So where does this all go? And it may feel like I'm talking about some, very fine distinctions and very technical stuff here. And why do we really care? I think we really care both because you can get into disputes if you rely on a verb like to use. And because if you don't understand this fundamental concept, there's a lot else about your copyright licenses that you might not understand. So let's talk about the solution. How do you solve this problem? What use of the verb to use do you want to actually make? So let's look at it first from the customer's point of view, and then from the vendor's point of view. From the customer's point of view, there's no particular harm in receiving a license to use software. What you want to do is make sure that it's clear the rights that you actually need under the copyright statute are also included. So let's go back to my example. Let's say it's necessary or at least convenient for you as the customer to be able to change the software, to modify it. You would want your license to use to include the right to modify. Vendor hereby grants customer a license to use 50 copies of the software and to modify the software as set out in attachment B. Maybe you have some attachment that defines what modifications you can make. You're creating a derivative work. That's the copyright term. Or maybe it's undefined. Or let's take the other example. I mentioned in order to really effectively use the software, you need to share it with someone. So vendor hereby grants customer a license to use the software. I would also add the license to reproduce, a license to reproduce the software so as to maintain 50 copies, a license to use the software, and then let's add the other necessary right, and a license to distribute the software to customers approved supporting users listed on attachment D, something along those lines. So in other words, as the customer, it's fine to receive the license to use. I don't think it's necessary. It's not doing you any harm, as long as you specifically list those of the 5 actual rights that you need. And by the way, this language I'm describing is available to you. It's in my book, the Tech Contracts Handbook, with explanations and descriptions. It's also available for free at our website, techcontracts.com, without the explanations, but you can get good contract language that does this stuff. So that's the customer's side of this, relatively easily solved if you understand what you're doing. From the vendor's point of view, I'd say the best thing is just to leave out the word "to use." You don't grant a license to use. You may restrict use, but you don't grant a license to use. Vendor hereby grants customer a right to reproduce the software so as to maintain 50 copies, or reproduce and modify the software as set forth in some exhibit, something along those lines. That's what I think is ideal for the vendor. Because this kind of silly habit has become so universal in technology contracts, if you might run into customers that insist that they receive the right to use the software. And if that happens, I don't think it's necessarily harmful to include it. So you give them the right to use, the right to reproduce, whatever other rights are necessary. There, as the vendor, your key to making sure that that vague and confusing term "to use" isn't misunderstood is you then list the rights that are not granted, so that there's no doubt about what "use," not defined by the law, includes and doesn't include. So there's usually a clause in a software license that forbids things like reverse engineering. Customer shall not reverse engineer, disassemble, deconstruct, etc. In a clause like that, you can stick something else. You can say, customer shall not they're always going to get the right to reproduce. Customer shall not modify, distribute, publicly perform, or publicly display the software. In other words, the rights that are not granted, you specifically say are not granted. That allows you to take sort of the teeth out of this issue. That allows you to take the teeth out of this problem of granting excessive rights. And again, all that language is available to you at our website for free. And obviously, I'd love it if you bought my book and it's explained there. There's three different chapters on this. All in all, the way you want to structure an on-premise software license is first you grant these rights, these copyright monopoly rights. And then you look at things like scope terms. That's my word for the language where you say that the right is only in a particular territory, or only for a particular period, or you have some kind of limit on how many seats are available, or concurrent users, or whatever the restriction you're placing on the software, or how many transactions the customer can run, whatever the restrictions. I call those scope terms. After you've granted the fundamental copyright rights that we're talking about, then you turn to these scope terms. There, it's not a problem to employ this verb "to use." You won't use the software for more transactions than X per month, whatever it might be. No problem there. But don't look at the verb "to use" as a copyright license right. It's not really what you're granting in your license, particularly if you're the vendor. You need to be particularly careful.
Well, you mentioned software as a service. Let's go there. You've also said that no one should grant a, quote, license to software as a service, but that's also common. Why not call that a license? What's wrong with it?
Yeah, so this is probably the other most common intellectual property misunderstanding and mistake in the realm of technology contracts. Here we're sort of pointing in a different direction. It's people granting a license to software as a service. And again, it's common language. Like you said, Kathy, it's very common to have these software as a service grants. Vendor hereby grants customer a license to the software as a service during the term. The problem here is, think about those monopoly rights I just described. They don't include the right to use. So you don't need to grant a license to the customer to use the software as a service. So what are you licensing? You certainly don't want to give the customer a license to reproduce your software. So software as a service, your software is sitting on your computers. Maybe you own them. Maybe you rent them from Amazon Web Services or somebody like that. But anyway, it's sitting on your computers and the customer never, ever gets a copy. I mean, that applies even in the cases where maybe there's some application that the customer does download that becomes on-premise software, but the main application is on your computers and the customer never gets a copy. My concern about granting a quote license, about using that word for software as a service, is it could be taken to imply some sort of intellectual property license. It could be taken to create an argument that a right to make a copy was granted, and it could do all sorts of other things. So I'm going to get back to what those things are. But the fundamental thing to understand is you're not granting a copy. You're not doing the fundamental thing that you do in an on-premise license agreement, which is say the customer make one or more copies and put them on customer computers. You're just granting access. So the word I like to use, which has no magic behind it, is subscription. You're giving a subscription, not a license to the software. You're giving the clause can say something like, during the subscription term, customer may access and use the software. Here's a perfectly good application of that verb to use. In other words, I'm making another, what may seem like kind of a picayune linguistic point. I'm saying don't use the verb license here, right? Or the noun license. Pick another verb, pick another term. I like subscription. So what's the problem if you do? You again might be thinking this is picayune language stuff. Why is he going on and on about this? So mostly this is a concern for the technology vendor. If you provide software as a service and you do use the word license, it might be fine. I'm not saying this is an automatic bomb that's going to explode in your face. You create a few risks that you didn't need to create. One is there could be an argument at some point in the future that you actually did grant a copyright license. Creative lawyer for the customer in a dispute is going to argue that was a license to a copy and you got to give the customer a copy. Maybe they won't win that, but you have no reason to take that risk. There could be an argument that you've granted a patent license that you didn't want to grant. There could be an argument that the word license is in there because of a different type of intellectual property grant, a patent license. Copyleft is a concern. So this gets into a whole other sort of complicated topic that we talk about in our master classes, is what is open source licensing and how does copyleft licensing? That's the licensing that's often unfairly, inaccurately called viral. But the concern is that if you're distributing your software like on-premise software, you're triggering the obligations that surround copyleft licensing. You involve those restrictions. Whereas with software as a service, you didn't need to do that. The concerns that arise from the fact that you almost certainly do have copyleft licensed software somewhere in your code, somewhere in your software as a service, don't need to come up at all because you're not distributing copies. You're not granting copyright licenses. And so again, you create maybe a small risk, but a risk that you have copyleft problems and you didn't need to. And by the way, I just want to say a quick aside. Some of you heard of the AGPL, the Affero General Public License, and other Affero type licenses. These are licenses where the copyleft obligations are triggered by providing software as a service. It's not just triggered with on-premise distribution. So that's an issue that, so software as a service vendors can run into that. But anyway, to the extent that you're going to be dealing with normal copyleft licenses, avoiding the word to license likely helps you stay out of trouble. And then finally, there's bankruptcy implications. I mean, an intellectual property license survives bankruptcy under certain circumstances. It's kind of complicated. But anyway, you don't need to create that. So long story short, there's all this potential confusion and complexity that you create when you grant a license to software as a service. And if you just switch vocabulary, you eliminate all these implications. Again, the language is available to you in my book and at techcontracts.com. grants of access to software as a service that do not use the word license and use some other sort of less magical language.
So shockingly, we're at about time. Do you want to take one more quick question or should we wrap up?
Let's do the last question. Yeah.
Last question. So what about data licensing? What rights should they grant? How are they different from what you just described?
Yeah, so data licensing is another area where confusion surrounding intellectual property sort of burdens contracts. There's sort of two misunderstandings that surround the terms governing data, both in cloud services agreement, which is our main IT contracts context, and in more literal data licenses. And it's the idea that data is an asset like software that you would grant under the same sort of copyright license, but it isn't. So data is information. It's a big collection of information. You can't really own information. You imagine you own your data, but you probably don't have any very meaningful rights to your data. Your ownership is somewhat theoretical. Establishing in your contract, agreeing, say, customer owns the data, is not going to keep the vendor, for instance, from mining the data for useful information, from potentially contacting customers of yours that it finds in the data, because the fact that you own the data doesn't restrict that. So what do I mean? First of all, you can't have a copyright in information. Copyright covers expression. It covers a work of authorship. So it's like I mentioned my book. You can't copy my book and resell it. Please don't. But you can certainly use the information in it. And so I can use the information in your data if I want to, despite the fact that you have a copyright in it. So owning the copyright doesn't do a lot for you. You might think, okay, another form of intellectual property, my data is a trade secret. Not likely. The restrictions on the definition of trade secret are pretty tight and pretty strict. It has to be competitively useful information, competitively important, and you have to have taken reasonable steps to protect it. It's not likely that the whole data set that you're dealing with in, say, a cloud services deal has competitive value. It's more likely that little gems in it do. So trade secrets might apply to bits and pieces of your data set, but not likely the whole thing. You can own your data in a very loose sense. There's the concept of a compilation copyright. You own the compilation, might own the compilation of the data under copyright law, which gives you some relatively weak ownership rights. It gives you the right to keep anyone from taking the whole compilation and reusing it, redistributing it, et cetera. That's not going to keep anyone from mining it. It's a very limited set of rights. Long story short, ownership of data is not very meaningful. And as a result, licensing data is not very meaningful. You grant someone a license to your data, imagining, the only rights they have are the ones that you want them to have because you granted them the right to the data to the limited extent that they have to, for instance, access it to provide you with the cloud services. The best way to look at it is this. Yes, say that you own your own data. In fact, we have some additional things I recommend you say about ownership, which is the data is valuable property of the customer. The data is a compilation pursuant to copyright law. Substantial effort went into compiling and collecting the data. And again, this is language available to you in my book and at techcontracts.com. Those things will support and bolster your weak rights. But after that, move on to the contract as the source of your protection in data. And so, Kathy's original question was about licensing. Again, you can look at this as a license, but don't let that sort of trick you into a false sense of security that you don't need a lot of details in a data clause. You can grant the other party the right to access your data for the purposes defined in the contract, maybe for in order to provide software as a service or other cloud services. No problem. But don't imagine that you've effectively restricted what they can do if you don't say things like, don't mine our data. In other words, instead of just granting a license to data and saying you can only exercise the rights here, you need to go through very specifically and very clearly and say the things that you don't want the other party to do with your data. You say, vendor may access and use the data solely to provide the cloud services. Vendor shall not move the data other than as follows. Vendor shall not distribute the data. Vendor shall provide the following security to protect the data. In other words, don't rely on the concept of intellectual property, whether you think of it in terms of ownership or in terms of licensing, to protect your data. Recognize that intellectual property is a very weak vessel for protecting data, because data isn't like software. It's knowledge, it's information. And rely on the contract. You want to put terms in your contract that actually have all of the restrictions that you might think that the law would impose on the other party. All the things you don't want the other party to do with the data, you should spell out in your contract rather than relying on concepts of intellectual property to impose those. And again, that's all language available for free at techcontracts.com. And of course, in my book, the Tech Contracts Handbook, where it's explained in much more detail.
Well, now we definitely are past time. As always, where can our viewers go to get more information and to remind themselves of the points that have been made here?
Yeah, so I've repeatedly, of course, mentioned the primary source is both our website, techcontracts.com, and my book, the Tech Contracts Handbook. The third edition is the most current. You'll also see running across the screen our master classes. So we have this 4-part total of 8 hours masterclass on information technology contracts, and we cover all of this stuff. And incidentally, you can take one part or all 4 or any combination thereof of the masterclass. The topics that we've discussed here today are covered. The license to software and the subscription to software as a service are in the first session, and all this stuff about data and how to quote license it and manage it is in the second session. So we're running the masterclass program in January, and you can see that on your screen. It's on the 10th, the 12th, the 19th, and the 26th. And by the way, their CLE credit is approved in California. For those of you who are attorneys and are in California, that is on time to get all of your CLE in by the February 1st deadline this year, if you're in the third of the population that has that deadline. So much more on this stuff available in the master classes. Also, I've got 3 articles that touch on these concepts. One is called Don't Use License Agreements for Software as a Service. Another, Avoid Licenses to, quote, Use Software. And a third, 10 Key Data Terms in IT Contracts, an Issue Spotter. And I'm going to put links to all of those in the comments for this program, so you can go right to those articles, which hopefully should provide further help. And that covers it. Thank you very much for joining us. Hope to see you at the master classes. Hope to see you at a future LinkedIn Live. And thank you very much, Kathy.
Thank you. And I'll put a quick comment, Dave, about the master classes. We have had students who find with their busy schedules it may be hard to attend them all live. So know that they are available to registrants for a 30-day period after each class.
Yeah, thank you. Yeah, so it's if you're not there live, you can't ask live questions in the comment, but otherwise you get the whole content. We provide a certificate. The certificate is the same. You get the whole deal if you do remote and off time. So hopefully that's useful to everybody. Okay, thank you very much.
Thank you, David.
See you soon. If you found this video useful, please come check out Tech Contracts Academy. We provide training on drafting and negotiating contracts about artificial intelligence, cloud computing, and other forms of software. It's all for lawyers, contract managers, and any business people involved with contracts. So please come check out our programs live and on demand at techcontracts.com.